Welcome to today's Explainer. Today, we're unpacking a truly fascinating and, honestly, deeply impactful piece of legal history. We're talking about the 2005 constitutional court case of Sibiya v. Director of Public Prosecutions. You know, we so often think of landmark court decisions as the very end of a story, right? A gavel bangs, a law is struck down, and society just instantly changes. But the reality, it's far messier than that. Today, we're taking a hard look at what happens after a massive historic victory. Back in 1995, the famous Makwanyane case officially abolished the death penalty in South Africa. It was an absolutely monumental human rights triumph. But how do you actually dismantle a death row? This seemingly dry, bureaucratic court extension request from a full decade later reveals a high-stakes, lingering reality of administrative chaos. We're going to dive into the paperwork, the sheer delays, and most importantly, the real human lives caught up in the machinery of justice. Okay, let's jump right into this, with a number that should immediately shock you: 62. By the year 2005, which is a full 10 years after that landmark Makwanyane case made the death penalty unconstitutional, there were still 62 people trapped in this awful legal limbo. That means 62 human beings were literally sitting in prison, technically still under a sentence of death, just waiting for their sentences to be officially replaced with an appropriate alternative punishment. A whole decade had passed. And honestly, this perfectly illustrates this central tension of what we're looking at today. The Constitutional Court was absolutely not having it. Justice Yakub, who wrote the judgment for unanimous court, laid it out incredibly plainly. He said the substitution of appropriate alternative punishments for the death penalty had taken far too long. Now, to put that into perspective, at the time of the abolition in 95, there were roughly 400 people on death row. And sure, while the vast majority of those sentences had been processed, leaving 62 forgotten individuals behind, that's a total failure of the system. The court felt it was absolutely crucial to express their deep concern that these fundamental constitutional rights were effectively being stalled by, well, bureaucracy. Section 1, the missed court deadline. This brings us right into the investigative phase, because the Constitutional Court didn't just sit back and express concern, they actually took action. Let's look at this ticking clock of accountability. On May 25th, the court issued a firm order giving the government a strict deadline of August 15th to report back with meticulous details on every single person still waiting. So what actually happened? Well, the government completely missed that strict August 15th deadline. Just 3 days before it, on August 12th, they finally filed a request asking for an extension until September 15th, just to get their paperwork together. Think about that for a second. They were late on a deadline about being late. Section 2, the interest of justice. So the highest court in the land has basically been ignored, or at the very least, delayed. What happens next? Well, in a constitutional democracy, a court doesn't just forgive your tardiness because you asked nicely, right? The government actually had to prove that granting their extension served a higher constitutional purpose. And that brings us to the interests of justice. This is a super vital concept under Section 167 of the South African Constitution. It's the standard used to determine if the Constitutional Court will even hear a case, grant an appeal, or in this specific instance, grant an extension of time. As Justice Yakub pointed out, extensions are not just handed out lightly. The court has to ensure that forgiving the government's delay actually serves justice, which means looking deeply at the context, how complex the request is, and really all the material circumstances. This whole situation builds into this truly fascinating legal balancing act. Justice Yakub had to weigh two hugely competing forces against each other. On one hand, you have the cogency of the government's explanation, like how complex was the information they were asked to provide. To be fair, they did have to collate 400 complex files from all over the country. But on the other hand, you have the severe prejudice suffered by the delay itself. The longer the court waits for this report, the longer those remaining prisoners are sitting in agonizing uncertainty, with unconstitutional death sentences still technically hanging over their heads. It's a really delicate weighing of administrative burden versus basic human rights. So what was the government's actual explanation for the delay? Their excuse, which they formally filed in their affidavit, essentially boiled down to, hey, it wasn't our fault. The Department of Justice claimed they had underestimated the sheer magnitude of the task, and they blamed a lack of cooperation from various court officials. They literally stated, strictly speaking, the matter was out of the department's hands. Now, the court noticed a pretty major problem with this excuse. Just a few months prior, in March, the department's own counsel had confidently promised the court that all 62 sentences would be fully replaced by the end of June. The court now had to reconcile that extremely confident promise with this brand new claim of total helplessness. Section 3, checking the homework. Despite those pretty contradictory excuses, the court ultimately decided that granting the extension was indeed in the public interest. Why? Because without that information, the substitution process couldn't be supervised at all. So on September 15th, this heavily delayed report finally arrives, and the government's homework did show some progress. The number of outstanding cases had dropped from 62 down to 40. But let's actually break down the bottlenecks for these remaining 40 people. According to the government's own tables, 24 of these cases had at least been considered by a judge and were waiting on the president's decision. But shockingly, 16 of these cases had not even been looked at by a judge yet. And of the 40 total, only 7 were expected to be completely finished by the end of September. The remaining 33, they were just pushed off to some undefined point after September. So where exactly was the entire system breaking down? Well, if we dive into the court's data and specifically look at the Mabato High Court, you'll see something pretty alarming. Out of these 16 total cases nationwide that hadn't even been seen by a judge yet, fully half of them, 8 entire cases, were just sitting dormant in the Mabato High Court alone. This level of precise data review is what allowed the Constitutional Court to see exactly which regional jurisdictions were completely failing to implement this constitutional mandate.
Section 4. The missing persons.
The court didn't just stop at the broad numbers, though. They heavily scrutinized the individual files, and what they found shifts this explainer almost into true crime territory. This is where the bureaucratic mask slips, and we see the glaring, totally unacceptable human errors. The court painstakingly audited this homework and actually named the men who were lost in the system. First, there was Mr. B.W. Poole. He was listed as having his sentence substituted, but the government provided 0 details on the new sentence or even the judge. His file had just been sent to the National Archives. The court demanded it be retrieved immediately. Then you have Mr. D.N. Bezudenhout. He was scheduled for a hearing in March, but then he just vanished from all the subsequent tables. Literally no one knew if he was resentenced or not. And finally, and undoubtedly most tragically, Mr. P.L. Khadijeh. The affidavit listed him as someone whose sentence still needed substitution. But another table, in the very same report, confirmed he was already deceased. He literally died waiting. This right here proves exactly why judicial oversight isn't just about shuffling paperwork. It is about human dignity and real human lives.
So how does the highest court respond to glaring errors like that? With the ongoing watch. Justice Yacoub and the Constitutional Court absolutely refused to let the matter drop. They declared that they would continue to personally supervise the execution of their own order until the entire process of replacing these death sentences was completely 100% finished. They issued a strict new deadline. The government had to fix the files of Mr. Poole, Mr. Bezudenhout, and Mr. Khadijeh and report back to the court by November 7, 2005. The court strongly asserted its ultimate authority to ensure the Constitution was actually being applied to every single citizen, no matter how long it took.
Which really leaves us with this final, vital question to ponder. If a court issues a landmark order but doesn't relentlessly supervise its execution, is justice truly served? The abolition of the death penalty was a massive, historic victory on paper. But as the Sibiya case so clearly shows us, declaring a right is really only the first step. Forcing the massive machinery of the state to actually recognize that right, line by line, file by file, and person by person, requires constant vigilance. It requires a court that is willing to ruthlessly check the homework. Thank you so much for joining me for this explainer. Keep questioning, keep learning, and I'll see you next time.